Appeal 1215 of 2022 is pending for consideration of bail appeals.
Item 185 from the list, my lord. Out of 10 years in custody, 9 years, some months, man. Can take.
Pardon, my criminal appeal, my lord, 20 years conviction, my lord, out of 20 years, 10 years.
My lord, item 59.
Enhancement of sentence. Criminal appeal, enhancement of sentence. He has already appeared in this case, opposite party. This honorable court was issued a notice, my lord. He has appeared in
Item 134, my lord. I-2219 of 2023 is only permitted to withdraw, my lord, and fixed for hearing. 134.
It is CRLA 1012
of 2022.
What you want to withdraw?
I-2219 of 2000.
There's an application for bail.
Bail, interim bail. Let's say kindly permitted to withdraw, my lord, or fixed for hearing, my lord.
Hearing. 2022 matter hearing.
Kindly permitted to withdraw item.
All right. IA number 2219 of 2023. This is an application for bail. Learned counsel for the appellant seeks permission to withdraw this interim application. Disposed of as withdrawn. 134. Yes.
Item 231 minutes. That is an OPID bail matter, my lords. It should have been come on heading fresh admission.
हाँ तो कहूनाती से जो आंकु से आसिले नहीं जो मैटर हमारा
From Mr. Bhuiya.
हाँ भुइया हूँ तो कि पात्र हूँ तो जी है ठीक है
Kalini.
हाँ खाली होगा जी को जेतो
Item 8 minute, can it be before or after lunch? This is a government appeal, my lord.
wait
The government appeal against inadequacy of sentences. Against order of conviction, another appeal has been filed. It has to be tagged. Let it go tomorrow or after lunch.
all right after lunch we can take up
Lordship, today list item 163. Lordship, today weekly list 163. Kindly taken up today, Lordship.
why
Lordship, he is near about 7 years in conviction, Lordship.
okay yes
Pardon to mention, my lord, the IAA filed for stay of order against the judgment of Land Special Judge Vigilance, Baripada. My lord, lordship have granted the bail in this case, but stay order has not been granted.
stay of the
Stay of the judgment. Otherwise, the penalty.
stay of conviction matter.
My lord.
It's a vigilance case.
My lord.
All right, give the
Oblige.
mention code लेके
My lord, I am for 159 item. Out of 10 years, he has already served 7 year plus, my lord. Kindly taken up.
okay see वो serious yes
No, pardon, your Lordship. Item 12. Today's list item 12. Kindly hold on tomorrow, my lord.
12 it is CRLA number 810 of 2023. You have no power in this
No
case.
power on behalf of Sushant Kumar Sahu, my lord.
All right.
Tomorrow.
Yeah, you have received
Extra copy solve करे करना
अच्छा ताला उठाने की काले
Copy to supply on today, matter.
item number 12 पे लिखी दूँ तो
Next week, my lord.
learned counsel for the appellant the learned counsel for the state submits that in spite of the previous order of this court, extra copy of the criminal appeal memo has not been served on him. Let the learned counsel for the appellant serve an extra copy of the appeal memo by tomorrow. In the event of which the order dated so and so, purva order ta jo hitla issue notice shall be complied with. Please this matter date what is either, है ना? All right.
Quickly list item number 1.
May I think. Here, my lord, appellant challenge the order passed by the London Session Judge Jagatsinghpur convicting the appellant under section 304 part 2 323 34 of IPC.
7-year sentence.
My lord.
All right, hard admit to call for the trial court report. You supply the deposition copies to the London Council for the state.
In course of day.
The interim application, bail and stay realization of fine to be considered after receipt of the trial court. Yes.
I have already.
You are supplying just now. Mr. Das, London Council for the appellant, supplied kar do, supplied the deposition copies of the witnesses to the London Council for the state in court today. Baki IA, both the IA shall be taken in, shall be considered after receipt of the trial. Yes. Yes.
Earlier, appellant was bail.
It's all right. Let the trial court record come.
Item number 2.
Item 2, may I please, Lordship? The appellant convicted for 10 years under 20B 2C of NDPS Act.
Operative part of the judgment.
Page 38, man.
Running page na internal page?
Running, man.
Running page 38. Okay. 10 years, so 20B 2C. All right. Same order.
Deposition I have already annexed, my lord.
अच्छा deposition दूसरे के लिखी हुई से annex चाहिए खाली admit करी trial court record.
Island I, my lord. That is 2914/23 for interim bail. Marriage of the appellant daughter was fixed month of January, my lord. Can take instruction that.
अच्छी सेटा.
I dey so.
Mr. Das.
Annex 2.
नहीं से I8 अच्छी देखले 2914 2849 मैंने से बड़ा छाड़ दिया से कौन बाहागर भौणी रो से नहीं give another copy IA number 2914 of 2023 से सेटा परे विचार अब आगे इटा नहीं जान this is an application for interim bail on the ground of daughter's marriage of the appellant which is stated to be fixed on 19th January 2022. Marriage invitation card has been annexed to the interim application. Let a copy of the interim application be served on the London Council for the state by tomorrow. Will obtain instruction on the amendments taken on the interim application. Put of this matter, give a date for consideration of the IA. You know? It will come, man. 1 week after it will come because the date is there since January masre bahagar achi. January achi. January 19 re achi. से IA number टा केते कहले next
item number 4.
May I please also Lord operative part at page 64 fourth paragraph my lord 10 years conviction for
running page na internal page
running page
64
yes paragraph 4 10 years conviction for the offense under section 395 of IPC.
395. All right. So admit call for the trial court record, interim application for bail, stay realization of fine to be considered after receipt of the trial court record. Interim bail would have
Yes, my lord. He was shifted to hospital because of some cardiac problem, my lord. For that,
Nije petitioner.
yes.
All right. You have received that copy, Mr.
2871.
IN number 2871. সেটা আগে instruction নিয়ে যান। IN number 2871 of 2023. This is an application for interim bail on the ground that the petitioner कौन করতে কিছু লেখা হয়নি?
Let's paragraph 2.
2 my lord.
2.
That the petitioner is suffering from cardiac problem and he has been shifted to the hospital. Land Council for the state has received the copy of the interim application and seeks some time to obtain instruction. List this matter on date and terms. IA number 871 of 2023. All right. And you supply also the deposition copy.
My lord,
Deposition copy.
My lord.
Supply. Yes.
S.K.SAHOO.
Item 5.
May please. Appellant convicted under section 37.
The petitioner was convicted for offense committed under section 354 for 2 years simple imprisonment.
Page operative.
Page 18, page 18 of the judgment.
Sentence to undergo simple imprisonment
2 years.
2 years.
While acquitting him on
5,000 and
3 and 506.
You are on bail during trial?
Yes, I was in bail during trial.
Yes, Mr.
And now also I am on bail.
All right, admit. He was on bail during the he was on bail during trial, and after conviction also he has been released on interim bail by the London trial. So bail allowed, stay realization of fine.
Item 7.
One of the conviction of
written instruction received from officer in charge of Bolani Police Station, Keonjhar, dated 29/11/2023, to the effect that no DNA test has been conducted in this case. Okay. The written instruction is taken on record. Yeah.
Item number 11.
May plus may. Has to be lordship directed for examination of
Examination of
ମାନେ ଏଟା ଆଇ ୱିଟନେସ୍ ଏକ୍ସାମିନେସନ ହଉଥିଲା ଗୌରାଙ୍ଗ ଭଗର୍ତ୍ତି ଏଟା ଲାଷ୍ଟ ଟାଇମ ଥିଲା 30/10 ରେ ତା ଆଗରୁ ଆଉ ଗୋଟେ ଡେଟ୍ ଥିଲା ସେଥିରେ ବି ପଡିଛୁ ହେଇଥିଲା ସେ ହେଇପାରିଲାନି 30/10 ହେଇଥିଲା 30/10 ରେ ବି ମାଜିଷ୍ଟ୍ରେଟ ଅନ୍ ଲିଭ୍ ତ ତାପରେ ନେକ୍ସଟ ଡେଟ୍ ଟା କେବେ କହିଛି ମୋ ଇନଷ୍ଟ୍ରକ୍ସନ
କଣ ଏଟା ଅଫେନ୍ସ କଣ?
Hence, my lord,
302 my lord
302
same footing other persons have been released on bail.
ଆପଣଙ୍କର ଆଗରୁ ରିଜେକ୍ଟ ହେଇଥିଲା ନା?
No, my your loss. Next, my lord, orders.
What is the next date?
I have to take instruction. I have not.
You each on leave, my lord, not joined.
No, PO is on leave ଯେ ଆପଣଙ୍କର ଡେଟ୍ କେବେ ରହିଛି? ପାଟନାଗଡ଼ ଏଡିଜେ କେବେଠୁ ଛୁଟି ରହିଛନ୍ତି କୋଉଠି?
ମାସେ ହେଲାଣି ରହିଲେଣି ଏବେ ଚାର୍ଜ ଅଛନ୍ତି କଣ୍ଟାବାଞ୍ଜି ଏଡିଜେ।
କଣ୍ଟାବାଞ୍ଜି
ଏଡିଜେ
ସେ ଯିଏ ଚାର୍ଜ ଥାଉ ସିଏ ମାସେ ହେଲାଣି ଅଛନ୍ତି। ଆଚ୍ଛା ଡେଟ୍ କେବେ ଅଛି ବୁଝନ୍ତୁ। ଏଇ ଯୋଉ ଶୁଣ ସେ ପାଟନାଗଡ଼ ଶୁଣ ରେଜିଷ୍ଟର ଜୁଡିସିଆଲ ପଚାରିବ ପାଟନାଗଡ଼ ଏଡିଜେ ଶ୍ଵେତା ମିଶ୍ର କେତେ ଦିନ କଣ ଛୁଟି ନେଇଛି କେବେ ଜଏନ୍ କରିବାର ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି କି ହେଲା ଆଉ ଏଇଟା ବୁଝିକି ଲୋକାଲ କାଉନସିଲ ପଚାରି କୁହନ୍ତୁ 500 ବର୍ଗ ରଖୁଛି।
Item number 13.
Please, your lordship.
Item number 17.
State Council submitted a notice on the informant has been made sufficient, however, he has to retrieve case diary and instruction about the criminal. पाइले की
ଆଜ୍ଞା
ଆଉ
ନୋଟିସ୍
notice
26/11
CRLA 972/2023 Tulu Behra. Date of custody
3821.
3821 ଆଗରୁ ଆସିଥିଲେ
ଆଗରୁ ବେଲ୍ ପିଟିସନ ଫାଇଲ ହେଇଥିଲା ନାଇଁ ଆଗରୁ ଆସିଲେ
ଆ ନା କଣ
ଟୁଲୁ ବେହେରା
ଟୁଲୁ ବେହେରା ନାଇଁ ଆଗରୁ ଆସିନଥିଲା ଠିକ ଅଛି so what are the offenses under which charge sheet submitted
363
363 364
362
yes
201 379 120B 109 506 read with section 34 IPC and under section 31R 2VBA of SC/ST POA Act
2V और
2V and 2VBA
VA V olga V olga
Aye.
dita
Aye.
so have you got that statement of the victim
Mela.
Or-
Mela,
no,
this is not this is 302 Mela.
302
302 तो कोई
Well, I'm sorry. Charge sheet date bull like I
Achha.
said 302 is there.
okay
My lord has dealt with one CRLA 147/2023. In that case, Minno Ketan Naik was released on bail.
कि कितना number CR
147/2023.
147
My lord.
147
My
of
2023.
2023
Yes.
Minno Ketan
Minno Ketan Naik.
Naik.
अच्छी order अच्छी
Order तो नहीं मु लिखी जी petition रे
Upload
देखी upload ହେଇଛି କଣ ବାହାର କଲେ
upload ହେଇଛି ସେଥିରେ 201 ରେ ତାକୁ ଛାଡିଛନ୍ତି
ହଁ
only 201 allegation is there against it.
ୟା ନାରେ
And so far this petition is concerned, also mentioned, my lord, the witness, one witness, my lord, eyewitness, my lord, unknown Naik. He has stated,
ठीक है आराम से ठीक उठे दो आई विटनेस
to the occurrence to at the time of kidnapping, because there is no direct eyewitness regarding the murder. When he kidnapped the
ସେଥିରେ ଆକୁ ଇମ୍ପ୍ଲିକେଟ୍
ନା ସେଥିରେ implicated ସେଥିରେ ନେଲା ଦି ଜଣ ନା ସେ ନାଇଁ ଟୁଲୁ ବେରା ନା ଅଛି ନା this presentation name is there. I am reading out the
what is the name of that eyewitness
my lord Anand Naik ସେ ଯେ order ଟା ବି Anand Naik statement ଟା place ହେଇଥିଲା ବି ମୁଁ ଖାଲି ଯୋଉ portion ଟାରେ ତାକୁ kidnap କରୁଛି ସେଟା କହୁଛି ପୂର୍ବାହ୍ନ ପ୍ରାୟ 5 ଘଣ୍ଟା ସମୟରେ
ଏ କପିଟା ବାହାର କର ତାର ଫାଇନାଲ ଡିସ୍ପୋଜାଲ
8ଟା ହେଇଯିବ 8ଟା ହେଇଯିବ
8 ଘଣ୍ଟା
8
ଏଟା ବେଲ୍ ଅର୍ଡରଟା ତ ନା ଅନ୍ୟ କୋଉ ଅର୍ଡର ବାହାର କରୁ ସ୍କ୍ରୋଲ ଡାଉନ
এটা ইংলিশ একটা মানে 5
আমার ওইটাও সেটা
স্ক্রোল ডাউন
সে যে অক্ষর ହେଇଛି তুমি এଥିରେ ଛାଡ଼ 8ଟା ସମୟ
ସ୍କ୍ରୋଲ ଡାଉନ
ଓଡ଼ିଆରେ 5
ହଁ ଆହୁରି ହଁ ଏ ଆର ଗୋଟେ ପ୍ରିଣ୍ଟ ବାହାର କରିଦିଅ ହଁ ପଢନ୍ତୁ କଣ ହେଲା ଆନନ୍ଦ ନାୟକ କଣ କହିଲା
ପୂର୍ବାହ୍ନ ପ୍ରାୟ ସନ୍ଧ୍ୟା 8 ଘଣ୍ଟା ସମୟରେ ଚଟୁଅ ଛକରେ ଭାଇ ସତ୍ୟବ୍ରତକୁ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଓ ଟୁଲୁ ବେହେରା ଭେଟି କଥାବାର୍ତ୍ତା କରିଥିଲେ ଓ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଓ ଟୁଲୁ ବେହେରା ତାଙ୍କୁ ଜବରଦସ୍ତ
ଲୋକଟା ନାଁ କଣ ଯିଏ ଯୋଉ ଡିସିଜ୍ଡ ନାଁ
ସତ୍ୟବ୍ରତ ନାୟକ
ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଟୁଲୁ ବେହେରା ତାଙ୍କୁ ଜବରଦସ୍ତି ଏକ ମୋଟରସାଇକେଲ ରେ ବସାଇ ନେଇ
କିଏ
ଯାଉଥିବା
ନେଲେ କିଏ
ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ and ଟୁଲୁ ବେହେରା the present petition matter ଜବରଦସ୍ତି ଏକ ମୋଟରସାଇକେଲ ବସାଇ ନେଇ ଯାଉଥିବା ବେଳେ ମୁଁ ଓ ସନ୍ତୋଷ ନାୟକ ଦେଖି ପଚାରିବାରୁ ସେମାନେ ଗଙ୍ଗପୁରରେ କାଲି ଏକ ମିଟିଂ ଅଛି କହି ତାକୁ ଜବରଦସ୍ତି ଏକ ମୋଟରସାଇକେଲ ବସାଇ ନେଇ ପଳାଇଲେ। ରାତି 11ଟା ପର୍ଯ୍ୟନ୍ତ ସତ୍ୟବ୍ରତ ଘରକୁ ନ ଫେରିବାରୁ ତାଙ୍କ ମୋବାଇଲ ଏତିକି ନମ୍ବରକୁ ଫୋନ କରିବାରେ ଫୋନ ସୁଇଚ୍ ଅଫ୍ ଦେଖାଇଲା। ଭାଇ ଫୋନ ନ ଉଠେଇବାରୁ ଆମ ଘର ଲୋକ ଭୟଭୀତ ହୋଇଯାଇଥିଲେ ଏବଂ ଆଖପାଖରେ ଖୋଜାଖୋଜି ଭାଇଙ୍କ ଖବର ମିଳିଲା ନାହିଁ। ତା ପରଦିନ ଅର୍ଥାତ୍ 2/8/2021 ସକାଳ 10 ଘଣ୍ଟା ସମୟରେ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଏକ ହିରୋ ହୋଣ୍ଡା ମୋଟରସାଇକେଲରେ ଆସି ମୋ ପୁତୁରା ବସନ୍ତ ନାୟକକୁ କରଡ଼ଗାଁ ଆଦିବାସୀ ସାହି କାଜୁ ଜଙ୍ଗଲ ମଶାଣୀକୁ ଡାକି ନେଇଯାଇଥିଲା। ବସନ୍ତ ମଶାଣୀରେ ପହଞ୍ଚି ଦେଖିଲା ତା ଭାଇ ସତ୍ୟବ୍ରତକୁ ପିଠି ହାତରୁ ରକ୍ତ ବାହାରୁଥିବାରୁ ତାଙ୍କୁ ଏକ ଜୁଇରେ ଲଗାଇ ଦିଆଯାଇଥିଲା। ଭାଇଙ୍କ ମୁହଁକୁ ଦେଖି ବସନ୍ତ ଚିହ୍ନିଥିଲା। ସେହି ଜୁଇ ପାଖରେ ସପନ ନାୟକ ବସନ୍ତକୁ କହିଲା, ତୋ ଦାଦାଙ୍କୁ କାଲି ହାର୍ଟ ଆଟାକରେ ମୃତ୍ୟୁ ହୋଇଯାଇଛି, ତେଣୁ ତୁ ମୁଖାଗ୍ନି ଦେ। ବସନ୍ତ ମୁଖାଗ୍ନି ଦେବାକୁ ଅରାଜି ହେବାରୁ ମଶାଣୀରେ ଉପସ୍ଥିତ ଥିବା ସପନ ନାୟକ, କରଡ଼ ଗ୍ରାମର ଟୁଲୁ ବେହେରା, ଖୋର୍ଦ୍ଧା ହଳଦୀପଦା ଗ୍ରାମର ବିଜୟ ନାୟକ, ନିମପଡ଼ାର ସୋୟଂଶ, ଶ୍ୟାମଘର ନାୟକ, ପିପିଲର ସୋୟଂଶ ଏଣ୍ଡ ବୈକୁଣ୍ଠ ନାୟକ, ଯୋଗେଶ ନାୟକ ଅନ୍ୟମାନେ କାଠ ବାଉଁଶ ଟାୟାର ଜାଳି ପୋଡ଼ି ଦେଇଥିଲେ। ଦିନ 3ଟା ବେଳେ ଶବ ପୋଡ଼ା କାମ ସରିଥିଲା। ବସନ୍ତ ହାତରୁ ମୋବାଇଲକୁ ନେଇ ସପନ ନାୟକ ଛଡ଼ାଇ ନେଇଥିଲା ଏବଂ କହିଥିଲା ସଂଗଠନ କାର୍ଯ୍ୟ ନ କଲେ ଏହିପରି ଶାସ୍ତି ମିଳିବ।
No, how do you say that this man is similarly situated?
Not similar.
Minoketan.
Minoketan is not similarly situated.
He is
He
the
is only
person.
201.
He is the person who
Only
that
standing in at the time of the
right. So it's a ସେ ଲୋକଟାର କେବଳ ସେ ଯୋଉଠି ପୋଡା ହଉଥିଲା ସେଇଠି ଥିଲା। ତେଣୁ ୟାର
ଏମାନେ ନେଇକି ଯାଇଛନ୍ତି ମୋଟରସାଇକେଲ।
2 ଜଣ ତ ନେଇଛନ୍ତି ଡିସିଜ୍ଡ କୁ, 2 ଜଣ ନେଇଛନ୍ତି। ଜଣଙ୍କର ନାଁ ହଉଛି ସ୍ୱପ୍ନେଶ୍ୱର ଆଉ ଟୁଲୁ। What about Swapneshwar?
Swapneshwar, I think he has not yet to be released.
No.
Your Lordship will kindly see this. Ananda said that mu ebong Santosha,
when they saw the
while he was being taken.
No, what is the date?
2/8. No, 1/8. 1/8/21.
1/8/21 ରେ
At about 8 p.m.
ରାତି 8ଟା।
ଆଜ୍ଞା।
1/8
ହଁ 1/8 ତାପରେ ଡେଡ ବଡି କେବେ ପୋଡା?
ନେକ୍ସଟ ଡେ
2/8 ସକାଳୁ।
2/8 ସକାଳୁ। ତ
FIR ଲଜ ହେଲା 3/8 ରେ।
No, how do you claim parity with Minoketan?
My lord, your lordship will kindly see this. Ananda says that he and Santosh Naik, they asked Tulu Behra and Swapneshwar where they were taking the deceased. Santosh doesn't say anything about it.
Santosh कौन था ना?
Santosh Naik. May I place it? Santosh Naik.
ଆନନ୍ଦ ନାୟକ କହୁଛି ଯେ ମୁଁ ଆଉ ସନ୍ତୋଷ ନାୟକ ପଚାରିଲୁ, ଦେଖିନି। ଆଉ ଥରେ ପଢିଲେ ସେ ଲାଇନ ଟା।
ଆନନ୍ଦ ନାୟକର ହେଲା। ଆନନ୍ଦର ହେଲା ସେଠି ମୁଁ ଓ ସନ୍ତୋଷ ନାୟକ ଦେଖି ପଚାରିବାରୁ ସେମାନେ ଗଙ୍ଗପୁର କାଲି ଏକ ମିଟିଂ ଅଛି କହି ତାଙ୍କୁ ଜବରଦସ୍ତି ନେଇଗଲେ।
Alright, so Santosh.
Last ଅଛି।
You have got that statement with you?
Madam,
pass. Read it.
ଗତ 1/8/21
କାହା statement ପଢୁଛନ୍ତି?
ସନ୍ତୋଷ ନାୟକ
ପଢନ୍ତୁ।
ଗତ 1/8/21 ଅଭିମାନପୁର ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଘର ପାଖରେ ଥିବା କୋଠ ଘରେ ମିଟିଂ ହେବ ବୋଲି କହି ମୋ ସହିତ ସତ୍ୟବ୍ରତ ଛବି ଓ ଅନ୍ୟମାନଙ୍କୁ ଡାକି ଏକ୍ଜିକ୍ୟୁଟ କରିଥିଲେ। ଆମେ ସମସ୍ତେ ସେହି ମିଶ୍ରଣ ପର୍ବରେ ଯୋଗ ଦେଇଥିଲୁ। ଏହି ମିଟିଂରେ ଏକ ବ୍ୟାନର ମଗା ଯାଇଥିଲା ଯେଉଁଥିରେ ଗୁରୁଜୀ ମାନସ ଦାସ ଓ ବେଲେଶ୍ୱର ପରିଡ଼ାଙ୍କ ନାମ ଉଲ୍ଲେଖ ଥିଲା। ସେଦିନ ମିଟିଂରେ ସତ୍ୟବ୍ରତଙ୍କୁ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ବେଇମାନ ବୋଲି ଆଖ୍ୟା ତାର ଆଣ୍ଠୁରେ ଗୋଡ଼ି ଦେଇ ଅଣଠେଇ ଥିଲେ। ତଳା ସୋ ମାଡ଼ ହେଲା ସମୟରେ ଗାଁ ଲୋକ ସାମ୍ନାରେ କହିଲେ ଯେ ମାନସ ଦାସଙ୍କ ଆଦେଶରେ ସେପରି ପୂର୍ବରୁ ମାଡ଼ ହୋଇଥିଲା, ସେପରି ସତ୍ୟବ୍ରତ ନାୟକଙ୍କୁ ମାଡ଼ ଦିଆଯିବ ଓ ଦରକାର ହେଲେ ଜୀବନରେ ମାରି ଦିଆଯିବ। ତାପରେ ଆମେ ସମସ୍ତେ ଚୁପଚାପ ହୋଇ ରହିଲୁ। ସେମାନେ ସମସ୍ତେ ଗୁରୁଜୀଙ୍କ ଆଦେଶ ଗାଁ ସାରା ମାନିବାକୁ ବାଧ୍ୟ ବୋଲି କହିଥିଲେ। ପରେ 2/8/21 ତାରିଖ ରାତିରେ ମୁଁ ବସନ୍ତ ନାୟକ ଠାରୁ ଜାଣିବାକୁ ପାଇଲୁ ଯେ ଗୁରୁଜୀ ମାନସ ଦାସଙ୍କ ଆଦେଶରେ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ଆଜି ଆସି ସତ୍ୟବ୍ରତ ନାୟକଙ୍କୁ କରଡ଼ଗାଡ଼ିଆ ଗ୍ରାମକୁ ନେଇ ସେଠାରେ ମୁଦେଲା ମାନେ ସ୍ୱପ୍ନେଶ୍ୱର ନାୟକ ସହିତ କରଡ଼ଗାଡ଼ିଆ ଗ୍ରାମରେ ଟୁଲୁ ବେହେରା ଖୋର୍ଦ୍ଧା ପଡ଼ ଶୁଣସ। He was not Vasanta Naik. This Santosh Naik never said that while the Satyavrata was being abducted, he asked the person and he said Swapnasar Naik was taking.
No, abduction କଥା ସେ କହିଛି କି ଟୋଟାଲି?
ନାଇଁ ନାଇଁ, କିନ୍ତୁ ଆନନ୍ଦ କହିଛନ୍ତି ମୁଁ ଆଉ ସନ୍ତୋଷ
ହଁ ଠିକ ଯେ, ମାନେ ମୁଁ ସନ୍ତୋଷ କଥା କହୁଛି।
ନାଇଁ, ସନ୍ତୋଷ କଥା କହିନି।
ସନ୍ତୋଷ ଏଭିଡେନ୍ସ ଷ୍ଟେଟମେଣ୍ଟ ରେ ସେଗୁଡା କିଛି ନାହିଁ ମିଷ୍ଟର ଦାସ? ଯେ ସେମାନେ ଦେଖିଲେ ଇଏ ସ୍ୱପ୍ନେଶ୍ୱର ଆଉ ଟୁଲୁ ତାକୁ ଜୋର ଜବରଦସ୍ତି ଡିସିଜ୍ଡ ସତ୍ୟବ୍ରତକୁ ନେଇଗଲେ ବେ।
ପରେ 2/8 ସେଠୁ ଆରମ୍ଭ।
ଆପଣ କେ ଦଶ ତ?
ହଁ
ଦେଖିଛି
2/8 ଆରମ୍ଭ।
ଦେଖିଛି ନାଇଁ
Or the learned counsel for the appellant, learned counsel for the state. The learned counsel for the appellant submitted that notice on the informant has been made sufficient, non appears for the informant. Learned counsel for the appellant further submitted that the appellant Tulu Behera is in judicial custody since 3/8/2021 and he has been charge sheeted.
No, charge sheet ହେଇନି। charge ହେଇନି କାରଣ SFSL ରୁ ଆସିନି।
No, charge sheet ହେଇନି।
charge sheet ହେଇନି।
What are you telling?
That is my information.
charge sheet ହେଇଛି ନା?
How can it be? Otherwise, you would have released it.
I am sorry, charge
You would have been released under 167.
I am very sorry.
Right. He has been charge sheeted under section 363, 364, 302, 362, 201, 379, 120B, 109, 506/34 of the Indian Penal Code, section 31R, 32B, of the SC/ST Act. It is further submitted that one co-accused, namely Minoketan Naik, has already been released on bail by this court in CRLA number 147 of 2023 as per order dated 8/5/2023. He files the copy of the order which is taken on record. Learned counsel for the appellant further submits that though one witness, namely Ananda Naik, has stated to have seen the co-accused Swapneswar Naik and this petitioner Tulu Behera to have abducted the deceased Satyavrata Naik on 1/8/2021 at about 8 p.m. But one witness Santosh Naik, who was along with that Ananda Naik, is completely silent regarding such abduction. Therefore, the abduction part is very difficult to be accepted. The learned counsel further submits that if that part is taken out of consideration, the only material remains against the appellant is commission of offense under section 201 of the Indian Penal Code, which is bailable in nature, and the co-accused Minoketan Naik, who has been released on bail, also stands on the similar footing, and therefore the bail application may be favorably considered. Stop. Learned counsel for the state, on the other hand, submitted that the co-accused Minoketan Naik is not similarly situated like the present appellant, but after going through the statements of two witnesses, namely Ananda Naik and Santosh Naik, fairly submitted that Anand's statement regarding abduction of the deceased Satyavrata Naik is not stated by the other witness, namely Santosh Naik. Considering the submission made by the learned counsel for the respective party, the nature of accusation against the petitioner, since the last seen part, as stated by witness Ananda Naik, is not there in the statement of Santosh Naik, and the rest of the allegation may at best make out a case under section 201 of the Indian Penal Code, and similarly situated co-accused Minoketan Naik has already been granted bail by this court, taking into account period of detention of the petitioner in judicial custody. I am inclined to release the petitioner on appellant on bail allowed. ये सील मार दे रहा हूँ फाइल को सीए सबमिट कर सील मार दे এটা নিয়ে আমরা 13 আর সেটা নেই যা
Item number 18.
Please, Your Lordship.
actual court ରୁ ଲେଖା ହେଇଛି ଗତ ଥର ଦେଖି ଦିଅନ୍ତୁ order ହଁ ସେ ଯୋଉଠୁ କୋଉଠି ଲେଖା ହେଇଛି ନା ନାଇଁ ଦେଖନ୍ତୁ ଗତ ଲେଖା ହେଇଛି ନା ନା ମୋ ଡିକେ ଜେନା କୋଉଠୁ appear କରୁଥିଲେ କୋରାପୁଟ ଆଚ୍ଛା କୋରାପୁଟ at ଜୟପୁର ହେଲା yes yes item number 21 Mr. Nanda
May I please your lordship? I am in VCB law.
As a notice Mr. Sahu is appearing and you have received the case diary
Lord's case diary was yet to receive it.
केतला डेट नेलेनी
Lord's
तीनटा गलानी
4 dates, your lordship.
हाँ तो कौन काई ये को थाना ये
Lord's
ये क्या होची पुरुषोत्तमपुर
काई तब कम्युनिकेशन करथिले
I've communicated yesterday by telephone, your lordship.
no no आगुरु जाइनी कि आपण
आगुरु 4टा चिट्ठी जाइछि, your lordship.
ताको appear करियो immediately send message all right I'm passing it over yes
Lordship.
ISU कोन तो appear करियो yes next
Item 22.
yes Mr. Tripathi
Please notice last occasion. Kindly see the last one.
हाँ कौन हला कोन तो
Lord, case diary is there in the connected matter, but about the instruction on the notice we have not yet received.
आपण पठेइले केबे
Lord's 3010 was the first letter, then 1411, then 2111.
हाजिर आवाज
Lordship.
yes
Item 24.
May
Item 25.
May I please, Your Lordship? The notice has been served of the State Council on 15/11/2023. This application for bail in the guise of
notice confirmation letter
Yet to receive, Your Lordship.
ଆଉ ଇଏ କେସ୍ ଡାଏରୀ
Case diary also we are yet to receive.
କେବେ ପଠେଇଥିଲେ?
Was 16/11 and then one on 29/11.
ହଉ କୁହନ୍ତୁ ଆସିବ ହାଜର ହବ. Yes, pass over.
Item 26.
will be taken up today, my lord.
ଏ ସେ ତ instruction ଦେବେ ସେ ସବୁ ହାଜର ହେବେ ଯେତିକ IIC ସବୁ. Yes.
My lord, the petition is in cost. This is the second round, my lord.
Wait.
First was rejected.
ଏଇଟା କଣ confirmation letter ଆସିଲା?
Case diary is there, Your Lordship, but confirmation report we are yet to receive.
କେବେ ପଠେଇଥିଲେ?
28/11, Your Lordship, and one on
28/11.
and another Lordship, another on 17/11.
17/11 ଦେଇଦବା କଥା. କୁହନ୍ତୁ ହାଜର ହେବେ. Pass
Lordship.
over. Next.
My lord, a deposition copy. The two material witnesses have been examined. My lord.
Victim examine ହେଲାଣି. ଏଇଟା କଣ କି କେସ୍ ଏଟା?
302.
302. ହଉ confirmation letter ଟା ଦେଖିଲା ପରେ ଶୁଣିଦେବାର. Next.
Item 27.
Pass over ଏଇ ଯେଟା ଆସିବ ସେ IIC ହାଜର ହବ. Virtual mode. Yes, next.
My lord, item number 27 on behalf of Mr. Chand kindly be taken up tomorrow or next week.
Also, I may be pardoned, Your Lordship. I wrongly mentioned that in item 26. Also, item 26 I have received the case diary, Your Lordship.
What about confirmation letter regarding service of notice?
Confirmation is not there, so I'll make sure that
That's it. Yes, next. Item 27, what do you want?
Kindly be taken up next week or tomorrow.
And Mr. Mishra, you have received the case diary?
Yes, case diary I have received, Your Lord.
And what about confirmation letter?
Confirmation, I'll get it on the next week, my lord.
Okay. Land counsel for the appellant 6 for an adjournment. Land counsel for the state submits that he has received the case diary and he will get the confirmation letter regarding service of notice on the informant by next week. Put up this matter, adjourn the matter. Yes, next.
Item 28.
May I please, Your Lordship?
Item number 29.
Yeah, please. Last thing, Your Lordship, that statement.
Case diary is we have received. Notice has been made sufficient today itself.
Okay, then give some time. Land counsel for the state submitted that he has received the case diary, but notice on the informant is made sufficient today in order to enable the informant to appear through advocate to oppose the application for bail. Put up this matter in the week commencing from 18th of December 2023. Yes.
Item number 30.
Your Lordship, can be taken up.
Please use the mic properly.
Number 30 can be taken up next week, Your Lordship.
Next week, acha.
Yet to receive the CTCA.
And confirmation letter?
Also, we are yet to receive.
All right, land counsel for the appellant 6 for an adjournment. Land counsel for the state 6 some further time to obtain the CDCA and also the confirmation letter. List this matter, give a date. Yes, next.
Item number 32. Item 31.
Mr. Joshi.
Yes, extract is there. Notice to be issued, Lordship.
Fresh matter.
Fresh matter.
All right. Extra copy. Notice. CDCA. Okay. Next.
Item 33.
Fresh matter.
Fresh matter.
Same order. Extra copy by tomorrow. CDCA confirmation letter to be received. Yes. Next.
Item number 34.
May I please your lordship, my lord. 34, 35, 36. Erase order same FR.
Fresh matter.
Fresh matter.
All right.
The examiner I have annexed the
Extra
deposition copy, my lord.
copy. CDCA. Next.
He is appearing, my lord.
I am appearing for the information.
Oh, then it's all right. So
34,
you obtain the
35,
case diary.
My lords.
तीनटा को वकालत ना फाइल कर जानी.
Right.
अच्छा extra notice दरकार नहीं. खाली लिखी दियंतु. The so and so files wakalatnama for the informant which is taken on record. The name of the land and council be reflected in the cause list as well as in the top of the brief henceforth.
Last time while
Land
disposing,
council
my
for
lord.
the state seek some time to obtain the case diary as well as to instruction about the criminal antecedent, if any, against the appellant. Yes.
Short date because CD is available.
Good.
Because I have twice earlier filed.
The number
Yes.
I
have filed the deposition copy also.
Give the deposition copy. Next question तो उसका कोई बार कौन अच्छी आप यदि कूतरे अच्छी केस डे तो कोई दियों तो से number दे दियों so that you will find out whether it is available or return back. Yes.
Item number 37.
37, there is a delay of 13 days. This is
Okay. Next.
Item number 38.
May I please, your lordships? I am appearing through a VC. The appeal is filed within the time. The offence under the provisions of the SC Act.
Fresh matter.
Fresh matter.
You serve an extra copy, London Council.
My lord.
Mr. Badal Kumar Behra, London Council, appearing through virtual High Court Baleswar. Since one of the offences under section so and so, let extra copy of the criminal appeal memo along with the annexures be served on the Land Council for the state usual order. You serve it so that notice will go. Yes.
Item number 30. Item number 40.
40 Pavitra Kumar Paiko.
This is also an appeal against conviction.
Your lordship, kindly may pass over this matter. Your lordship seeking passover of this matter.
No, you are submitting
Only
from
for
which
NDPS. Yes, please, your lordship.
From which court you are submitting? Virtual court of which district?
From Ganjam.
Ganjam. Okay. If it's not operating, that system is not operating or what?
No, because some network is being here on my phone, your lordship. So it is cannot be just a video is not operating, your lordship.
What do you want here?
Your lordship, I'm seeking bail of this matter because your lordship, the accused person is in judicial custody since 2015, your lordship.
You have appeared for
on behalf of accused number 1, Your Lordship.
no, it's all right, but one prisoner petition has been received for that appellant number 1, Andrea Maji,
Please, Your
and
Lordship.
to engage you as his counsel, but you are to file the wakalatnama. You have not filed.
Yeah, I have filed, Your Lordship. I have filed on the last 29th of November 2023.
Okay. Let it be placed on record. The
Please, Your Lordship.
Mr. Pavitra Kumar Paik, Learned Counsel, appearing through virtual mode, submits that he has filed VNAMA for the appellant number 1, Andrea Maji, on 29/11/2023. Let the registry place the wakalatnama on record. Put up this matter next week. Yes. VNAMA to be placed on record. Yes.
Item number 41.
Passover. ଦେଇଛନ୍ତି deposition copy ଦେଇଛନ୍ତି rules ଦେଖ. What is the offense here?
376D.
ଦେଇଛନ୍ତି କି ଆପଣ?
Yes.
Okay. You want Passover? Okay.
Number 42.
Last person also directed for taking instruction regarding health status of the
Status
health status.
Regarding it's a case of conviction.
Yes, ma'am.
Criminal antecedent, if any, against the appellant, also the photographs of the affected body part of the injured, PW1.
10 years conviction out of in custody since 23/5/2019. At the time of occurrence,
Acid case?
no, ma'am.
Then
X
307.
I.
What is the weapon of assault?
X.
Huh?
X, ma'am.
X. Amputation.
Amputation of the hand. The amputation of the finger. 4 finger.
4. Where is the doctor evidence discussed?
Doctor evidence matter that PW11.
Who did discuss on AG?
Page 9.
9. Doctor is PW9. Okay. Page 9 so cut wound on the neck, 1. Lacerated wound.
That is one assault. He showed his hand and
Amputation of left thumb.
Art.
Okay. Amputation of dita guti. 3টা 4টা ଗୁଡି ଯାଇଛି. Grievous in nature. So
criminal accusation.
CA କଥା କଣ ହେଲା? Sentence is 10 years.
Yes, ma'am.
And what is the period you are in custody?
Since 23/5/2019.
23/5.
2019.
4 years 6 months out of 10. देखिए.
Yes.
Victim available କଣ record ତାକୁ ମୁଁ କହିଥିଲି ଆପଣ ଆଣିବାକୁ ଅବିକା ତାର କେମିତି କଣ condition ଅଛି?
PW10 melod the occurrence was occurred on 23.
Mr. Tripathi,
Yes, sir.
Learned Counsel for the state seeks some time to obtain instruction regarding CA. and also the photographs of the affected part. Bartaman taro se jo iero maybe that plastic surgery karthibo ki kon karthibo seithi pai apanku kahithili. ଆଉ ସିଏ ଆପଣ ରେକର୍ଡରେ ନାହିଁ ବୋଲି ଲେଖିଦେଲା କଣ ତାକୁ ଫୋନ କରି କୁହନ୍ତୁ ଯେ ଆଫେକ୍ଟେଡ ପାର୍ଟ ର ଇଏ କରିକିନି ଏଟା କାଲିକି ରଖୁଛି ପଠେଇଦବ ଆଉ କଣ ଆଫେକ୍ଟେଡ ପାର୍ଟ ର କ୍ଲିକ କରି ପଠେଇଦବ ଏଟା ରଖ କାଲି ମାନେ ହାତଟାକୁ ଦେଖେଇବ ତାକୁ କହିବ ଯୋଉ ହାତ
Item 43.
43. Though here is conviction under section 373, it is not the issue.
Notice jaini?
No.
All right, extra copy to be served on the learned counsel.
Item 48.
The appellant has been convicted of section
Deposition copy ଦେଇଛନ୍ତି?
Yes.
307 411.
Wait.
Page 62 is the sentencing part.
It's a case of conviction. You are on bail during that?
Yes, ma'am.
Now, you have been found guilty under section?
307 411.
What is the operative part of the judgment?
Page 62, running page 62 of my briefs.
62.
Internal page 53 of the judgment.
Okay. 10 years, 5,000 in default RI for 6 months. Okay, 307. Then RI for 3 years and 1,000 for 11. So 7 years, 25 and 27 answer. So it is 10 years, right?
Right.
What is the name of the injured?
No one is injured, ma'am. Rather, the appellant has been injured.
So it's a gunshot fired at whom?
Encounter.
Acha. So how many cases are there?
6 cases. I have filed comprehensive affidavit, my lord.
So is it a fact that nobody has sustained any injury?
No police person.
And he sustained injury?
Yes.
Stated by? Your doctor is PW?
I witnessed, my lord, PW 1, 2, 3,
4.
4.
No. Is there any medical report to the fact that you received injury?
Yes, my lord. Is evidence of all the witnesses.
Doctor is na name?
Yes.
Ketna number agi?
PW 15 million.
PW 15 doctor. Examine the appellant. I was the assistant professor so on that day injury on Suresh Rao. Okay, I reported the injury for attention. So admission है So you are on bail during trial. Let us see. UTP is produced. UTP. Accused is not produced.
Judgment shows, man, page 11, my custody.
You were granted and bail by this court. So ultimately you were released on from custody on 12/4/2021. Okay, and final form indicates that Suresh Raut was taken into custody on 4/2/2018, 5/5. So that means it is 3 years.
3 years, 2 months, 7 days.
2 months. Okay. Then conviction order was passed on 10th February. Judgment 10/2/2023. Yeah. That means another
9 months,
9 months. So about 4 years you are now custody out of
10 years.
10 years. What is your comprehensive affidavit, you said?
Flag.
Flag?
In one case, I have been released on bail, and in 3 cases.
No, where have you filed that comprehensive affidavit? You have got, he said that
Flag
you
C. Flag C.
Ketara criminal antecedent.
6.
Flag C টা করি। সেটা নেই। হ্যাঁ।
In item 1, I have been granted bail.
Hmm.
And 2, 3, and 4, my lord, I have been acquitted. And 5 and 6, I have not taken to custody.
Right. Heard the learned counsel for the appellant, learned counsel for the state. The learned counsel for the appellant submitted that the appellant was initially taken into judicial custody on 5/2/2018, and he was granted bail by this court and released from custody on 12/4/2021. And after the pronouncement of the judgment on 10/2/2023, again he was taken into judicial custody, and thus he has remained in custody for about 4 years in connection with this case. By filing the comprehensive affidavit, it is stated that out of the list furnished by the learned counsel for the state in 4 cases, the appellant has been acquitted.
3 cases. Item 1, I have been granted bail.
अच्छा और लिखी जो 1 to 4 बेली पेज नंबर कॉलम नंबर 4 को आसिले that it is humbly submitted that the petitioner has been acquitted in cases serial number 1 to 4. 1 to 4 টা চারটা না তিনটা?
Subsequently, I have filed another affidavit.
ଆଉ କଣ ଗୋଟେ ତ ଅଛି ଆଉ
And on 17/10, I have filed another.
17/10 এই ଦେଖିଲ କଣ 17/10 को हाँ दियो ସେଟା କଣ କଲନି କଣ ପାଇଁ ହଁ ଏଇଟା କଣ କମ୍ପ୍ରିହେନ୍ସିଭ ଆଫିଡେଭିଟ ଟା ଅର୍ଡର ଟା କଣ କହୁଛି ଏଇଟା 3/9 ର ଦିଅ P9 ଟା ଓ 17/10 17/10 ରେ ତ ସେଇଆ କରିଛନ୍ତି ଆପଣ ସେମିତି ଲେଖିଛନ୍ତି he has been acquitted in ଆଚ୍ଛା ଏଟା ସିରିयल ନମ୍ବର 2 to 4 ଆଚ୍ଛା ଲେଖନ୍ତୁ କଣ ଲେଖିଲେ 6 cases out of this Yes, see, list furnished by the London Council for the state regarding 6 criminal antecedents, the appellant has been acquitted in 3 cases, and in 2 cases, he has not been taken into custody, and the the other case is on bail. London Council further submits that nobody has sustained injury from the prosecution side. Rather, it is the appellant who has sustained injury during encounter and was hospitalized in SCB Medical College Hospital. Peruse the evidence of the witnesses, considering the submission made by the London Council for the respective parties, the nature of evidence adduced, the sentence imposed by the London Trial Court, the period already undergone by the petitioner in judicial custody, absence of any chance of early hearing of the criminal appeal in the near future. I am inclined to release the appellant on bail subject to condition that he shall not indulge in any criminal activities. Stop. Violation of any terms and conditions shall entail cancellation of bail. Allowed. Please. এটা নিয়ে ফাইলটা ওটা Yes.
Item number 49.
May I please?
The appellant convicted.
डिपोजिशन कॉपी ଦେଇଛନ୍ତି?
Appellant convicted under section 20B2C of the NDPS Act and sentenced to undergo 12 years and to fine 1 lakh.
सेंटेंस केते 12 इयर्स केते वर्ष हेलानी बेल ले थिले कि ना नहीं
हाँ
तो समुदाय
24/11/2018 I am in custody.
24/11/2018 ले 5 वर्ष हे गला आ बेल ले जाई ना थिया भीतरे
जाए
तो कस्टडी सर्टिफिकेट नहीं आसी
एनसीपी मैटर मिला
ओहो किए करियो कि
मिस्टर पंडास नेम देयर
सत्यव्रत पंडा पास ओवर कुर्ची खबर दियंतु तांगु टिके सत्यव्रत पंडा को
लास्ट टाइम मुझे कहते जे मु से अपेयर करबिनी कोन बिल लो ना कोन हेची किंतु एमती कहते मु कहले ता आपण तो रिसीव करचंदी ना
तो आंकु नले कम्युनिकेट करंतु आप तांकर से जो अन्य की ये पार्थ थिला ना कोन पार्थ नायक हां जाकुले से का गोटे एंगेज करिवे ना से कहि दी गले ना लिखाई गला अब तो आसुनांती तो पास ओवर करजे लॉन्च पर निया जीवो कहि दियो पास ओवर मैटर
Pass over item number 11.
11, I have taken instruction. You is joined today, and the next day is 4/1/2024.
The deposition of that eyewitness, na?
Yes, madam.
All right. The learned counsel for the appellant submits that the presiding officer has joined, and the next date has been fixed for trial is 4/1/2024. किए से आसियो ता नाटा कहले
Gaurav Bogarti.
गौरव
Bogarti.
the learned counsel for the state shall intimate the inspector in charge of police station no case ta Loramba police station to appear before the learned trial court, that is so and so in so and so case, receive summons in respect of witness Gaurav Bogarti, and ensure his attendance on the date fixed. A free copy of the order be handed over to the learned counsel for the state. अच्छा तक परे गोटे जो रही पकई देबे नेक्स्ट वीक रे will produce the certified copy of the deposition हला position copy yes
Item number 21.
What should I take up at 2 p.m. Yes, all 6
that is 3, 4, 5 matters. All right. এই जो 21, 22, 23, then 25 and 26. एगुड़ाक लॉन्च पर डाकिबे. Yes, next.
Item number 39.
39, Mr. Ramesh Chandra and Karunakar Goya. Nandi. Sharad Kumar Naik for the informant. You have received the deposition copies.
a custody certificate.
All right, we'll see that. Yes, go on.
Item 2081.
May I please your lordship, lords. In a case of trap, lords, the accused was convicted, but sentence part is concerned, lords, the land court passed the sentence less than the minimum sentence is 4 years. Your lordship, turn to page 41, the sentence portion order, lords. 41. Page 41.
Yes.
Page 41. Now, lordship, may turn to page 20 of that OLR publication, section 13.2, my lords. Any public servants may place that one.
No, the convict Ishwari
the opposite party accused, my lords.
RI for 2.5 years for the offense under 7 PCR.
Subsequently, 13.2.
Then a fine of rupees 10,000 in default to undergo further RI for 3 months. Then for the offense under 13.2 read with 13.1D, he is sentenced to RI for 3.5 years and to pay fine of rupees 10,000 in default to undergo further RI for 3 months. The substantive sentences of imprisonments are run concurrently. So
this is devotes to section 13.2. Lordship, turn to page 20 of the OLR publication. That after amendment is 4-year minimum sentence. Page 20, lords. Lordship, page 19, the section 13 starts.
Page kete kujandi?
Page 19, lords. 19.
19.
My lords. Page 13, section 13. Lords, you turn to next page, page 20. 13.2, my lords.
Just date of occurrence is?
Date of occurrence is 10/9/2014. The amendment came into force on 16 January 2014. The factum of demand and acceptance. Yes, the factum of demand and acceptance occurred on 10 September 2014, whereas the amended provision came into force on 16 January 2014, lords.
16 January 2014.
The amendment came into force, lords. No, I'm afraid may not be there. That is the 2018 amendments. Lordship.
So where is that?
Lordship, where is that? Section 10, section 13, 13.2, lords.
Any public servant who commits the criminal misconduct shall be punishable with imprisonment for a term which shall not be less than
4 years.
No, 4 years. It was substituted in
16 January 2014. It became 4 years. Now the occurrence took place in September 2014.
With effect from 16/1/2014.
The bottom portion, the amendment date is there.
9 yes, and which may extend to 10 years. Okay.
That is substituted to 4 years. 7 to 10. 3 also.
For 1 year, 7 months, and 2 years.
And if Lordship permits, lords, in the meantime, the accused has also prepared an appeal. Lordship can see the noting in that cost list that appeal is pending against the order of conviction.
So here you mean to say that so far as 13.2 is concerned,
My lords,
the
minimum should be 4 years.
So the minimum is 4 years.
Yes, my lord. With effect from January 2014. In this case, the incident happened. I mean, the demand and acceptance was made on 10 September 2014, 8 months afterwards, when the amendment was in force.
Sentence ta kodi hai ko pad rahe page
Running page 31 of the judgments, and in the petition it is 41.
But so far as the Section 7 PC Act is concerned, there is no problem there.
No, you're also correct.
7 PC Act.
There also shall not be less than 3 years, but 2.5 years.
7 PC Act, so and so.
Page 17 of the OLR publication shall be punishable with imprisonment, which shall not less than 3 years, but which may extend to 7. So here is 2.5.
No, that came into in 2018.
Yes.
What about this 2014?
January.
Will not be less than 3 years. 3 years to substitute for 6 months and 5 years. So आगे थिला 6 months और 5 years थिला. सेटा हेगला 3 years हेगला in 2016 2014.
Right.
All right. This JCRLA has been filed by the state of Orissa under section 377 CRPC.
For inadequacy of sentence.
Challenging the inadequacy of the sentence and for enhancement of the sentence passed by the learned additional session judge cum special judge vigilance Bhavani Patna in GR bracketary vigilance case number 17 of 2014 oblique TR number 14 of 2015. It appears that the respondents Ishwari Prasad Purohit and Kali Prasad Tandi faced trial in the said court for offences punishable under section 7 and section 13.2 read with section 13.1d of the Prevention of Corruption Act 1988. Hereafter for short PC Act and section 109 of the Indian Penal Code, hereafter IPC. The London Trial Court by judgment and order dated 24/6/2023. Operative portion was found both the respondents. No.
Yes.
Sorry.
Accused 2 is not found guilty.
Associate operative person. Found the
Ishwari Prasad Purohit.
Ishwari Prasad Purohit, that is respondent number 1. Guilty under section 7 and section 13 to read with section 13.1d of the PC Act. And so far as respondent number 2, Tanagon?
His name is Kali Prasad Tandi.
respondent number 2, Kali Prasad Tandi is concerned, as a portion of he was not found guilty under section 7 and section 13 to reduce section 13(1)(d) of the PC Act and section 109 of the IPC, and he was acquitted of all the charges. So far as respondent number 1 is concerned, he was sentenced to undergo RI for 2.5 years for the offence under section 7 of the PC Act and to pay a fine of rupees 10,000 in default to undergo further RI for 3 months. And for the offence under section 13 to reduce section 13(1)(d) of the PC Act, the respondent number 1 was directed to undergo RI for 3.5 years and to pay a fine of rupees 10,000 in default to undergo further RI for 3 months, and the substantive sentences of imprisonment were directed to run concurrently. When the criminal appeal JCRL has been filed for enhancement of sentence of respondent number 1, there was no need to implead the respondent number 2, Kali Prasad Tandi. Therefore, it is to be treated that the respondent number 2, Kali Prasad Tandi, is not a party in this GCRLA. The Mr. Sangram Das, Learned Standing Counsel for the Vigilance Department, submits that so far as the offence under section 9, the occurrence in question took place, the demand of bribe,
demand and acceptance of bribe.
The demand of bribe was took place on 9/2014.
10th 9, I think. 10th September.
No, 10th was accepted. Demand was on the 9th.
Prior demands.
And 8/9/2014 and the acceptance took place on 10/9/2014.
Correct.
The PC Act 1988, Section 7 of the PC Act 1988 deals with offense relating to public servant being bribed, and it is stated that any public servant who obtains, accepts, or attempts to obtain from any person any bribe, etc., shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 7 years, and shall also be liable to fine. And this amendment came into force by Act 1 of 2014 with effect from 16/1/2014. Similarly, 13(2) of the PC Act states that any public servant who commits criminal misconduct shall be punishable with imprisonment for a term which shall not be less than 4 years, but which may extend to 10 years, and shall also be liable to fine. And this amendment also came into force by Act 1 of 2014 with effect from 16/1/2014. And since the occurrence in question took place after 2014 amendment came into force, there is no power with the Lennon Trial Court to award sentence lesser than the minimum sentence prescribed for the offenses under Section 7 as well as 13(2) of the 13(1)D reduce 13(2) reduce Section 13(1)D of the PC Act. Inasmuch as both these section doesn't give any liberty to the court to reduce the sentence from the minimum punishment under any circumstances. The London Standing Council further submits that imposition of sentence lesser than the minimum sentence as prescribed under both the offenses is illegal and therefore liable to be set aside. Issue notice to the admit start issue notice requisites for issuance of notice to respondent number 1 Ishwari Prasad Purohit shall be filed within 1 week from today. The London Council submits that respondent number 1 has preferred criminal appeal number.
In that cause list indicates cause list, and the office has given the note. Case number is there at
692 of 2023 before this court, challenging the judgment and order of conviction. Henceforth, the GCRLA shall be listed with CRLA number 692 of 2023. Free copy of the order be handed over to the London Council for the
requisites within 1 week, notes.
Requisites within 1 week will be here. Eta deଇ ଦିଅନ୍ତୁ ଆମର yes.
May I please, Your Lordship? My Lord, the offences alleged under Section 448, 376, 511.
It was What is your name, Mr. IIC Purushottampur?
Lordship, Samir Kumar Rao.
कौन कହୁଛନ୍ତି? ଅନିଲ କୁମାର ରାଉତ?
Samir Kumar Rao.
ସମୀର କୁମାର ରାଉତ. So since when you are the inspector in charge of Purushottampur police station?
Lordship, 25th July 2023.
25th July. ଆପଣଙ୍କର ସରକାରୀ ଓକିଲ କହୁଛନ୍ତି ଯେ ଏଇ କେସରେ 4 ଥର ଆପଣଙ୍କ ପାଖକୁ ଗଲାଣି କେସ୍ ଡାଏରୀ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ଆଉ ପଠେଇବା ପାଇଁ ତଥା ନୋଟିସ୍ ଅଫ୍ ପାଇଁ ଆପଣ କିଛି ରିପ୍ଲାଏ ଦଉନାହାନ୍ତି?
Lordship, 2353 CRLMC 2353 by 23 submit reported.
हाँ कौन कहले?
CRLMC number 353/23
हाँ
update case diary submit करा
पठेई ଦେଇଛନ୍ତି
sir.
केस डायरी पठेई ଦେଇଛନ୍ତି ଆଉ ସେ ବିଷୟରେ କହିଲେନି ଯେତେବେଳେ 4 ଥର ଆପଣଙ୍କ ପାଖକୁ ଗଲାଣି ଯେ ପଠାନ୍ତୁ ବୋଲି କେସ୍ ଡାଏରୀ ଆପଣ କହିବାର ନଥିଲା କି ଯେ ଆଜ୍ଞା ଆପଣଙ୍କର ଆଡଭୋକେଟ ଜେନେରାଲ କ ଅଫିସ କୁ ଆମେ ଏଇ କେତେ ନମ୍ବର ରେ ପଠେଇ ଦେଇଛୁ ଅଲରେଡି ଟିକେ ଭେରିଫାଇ କରି ଦିଅନ୍ତୁ आ लेटर पाइकिन बसीगले लाभटा कौन है? तापर द्वितीय कथा थिला क्रिमिनल एंटीसीडेंट से विषय कौन है? हाँ क्रिमिनल एंटीसीडेंट आपन को कुहाई थिला से जो ये एक्यूज या ना होची कान्हू चरण बासंती ता नारे किछि केसबास अछि कि नाही से विषय जणैवा पई से विषय कौन आपनकर इंस्ट्रक्शन अछि?
दिया थिला केस डेट
हाँ
केस डेट दिया थिला सेथरे जहां
तार देर अछि. So it is available. Have you recorded
Yes,
that number? Yes. So henceforth, whenever any intimation is given from the AG office, respond to it. And if you have already sent the case diary in another case, just intimate the concerned state council so that he can find it out. Don't sit over the matter after receipt of 4 communication from the AG office. Otherwise, you are liable to face the contempt of court.
Sir.
You do it one thing. Tomorrow I will take up this matter. Search for that file.
Lordship.
Okay. Yes. Next case.
No, it will pass over or it will come.
It will come tomorrow from the weekly list. It will be called tomorrow.
Okay. Yes.
Yes. You will just find it out. The other case where the CD is stated to be available. Yes.
22 on behalf of J.K. Panda, I may be allowed to submit.
22 also as Lords, the IIC Dhenkanal's other PSs.
Mr. Pradeep Pradhan.
Sir, namaskar, sir.
आदिर केथर जाइए? Twice. तो मिस्टर प्रधान एजी ऑफिस रु ए प्रशांत कुमार राउत रो जो बेल दरखास्त होईची ताधरे आपन को केस डायरी और क्रिमिनल एंटीसीडेंट पठेवा पाई एवं इन्फॉर्मेंट ऊपर नोटिस जारी करी कन्फर्मेशन लेटर पठेवा पाई दिथर गलाणी इंटीमेशन आपन रेस्पोंड काउंट पाई करू नांती?
सर मु टिके मझिरे सर टिके छुट्टी पड़ेथिलु बोले से समय हे पानी सर सेति पे मु अपोलॉजी मागुची सर नेक्स्ट टाइम शॉर्ट डेट रे सर कर देबी सर
ए केस रो पठेलेनी
नहीं पठे पारिनी सर
ए केस रो आपण पाखरे वर्तमान रेडी अछि तो केस डायरी और क्रिमिनल एंटीसीडेंट ए विषय रे अछि तो
सर से केस रे आयो होछन हमर एसडीपीओ सदर सर सी टिके सर छुट्टी रे जाइछन सर 3 दिन पे सर आउ सर मो टिके छुट्टी रे पड़िथिले सर सेति पे पठे पा नथिले शॉर्ट डेट रे सर मु प्रॉमिस करछि पठे दे सर सेति पे
ओके 11th December 23 रे रखुची आपण केस डायरी और क्रिमिनल एंटीसीडेंट प्रशांत कुमार राउत रो कोन अछि किछि सेउडा पठेबे एवं इन्फॉर्मेंट को नोटिस जारी करी से विषय रे मध्य कोर्ट को जणेबे
सर नमस्कार सर
लिखूं Mr. Pradeep Pradhan, the IIC of Dhenkanal Sadar Police Station is present in virtual mode and he submitted that he will ensure the production of the case diary and criminal antecedent, if any, against the appellant. So also the confirmation later regarding service of notice on the informant on the next date. Put up this matter in the week commencing from 11th December 2023. Free copy of the order be handed over to the Land Council for the state. Yeah.
26 also pursuant to your lordship's direction. Lords, the IIC is on leave, but the additional IIC of Bhadrak Rural is there on virtual mode, your lordship.
Just a minute.
मैडम वीडियो टा ऑन करंतु ऑडियो टा ऑन करंतु
It is IIC of?
Lords, she is the additional IIC of Bhadrak Rural Police Station.
This case belong to Bhadrak Rural.
Bhadrak Rural, lordship.
So here also, how many times you have
CD, Lords, the CD I have, your lordship. Only the confirmation of notice
letter.
And 2 dates have been granted, my lords.
Okay. Who is the informant in this case?
Madhusudan Maji.
Huh?
Madhusudan Maji. The lordship, there seems to be a problem with her audio, your lordship.
Audio or video?
Audio, your lordship. We tried our best during the lunch break, but we could not fix it. Madam, please switch on the video.
What he is telling about
the whereabouts of the informant are not yet known to us. We're trying to find.
He should write it to you.
Yes, your lordship.
Because once you make such a submission, as such, it may not be, because tomorrow he may come out to recall that order.
Lordship.
But once it is based on a document filed by them, responsibility will be on them.
My lords.
Madam, आपनको मो कथा सुभा जाउची? No, he is not responding. So if you have talked, ask him to send a letter to you today.
Lordship
itself.
They're sending a letter. I've already informed them.
So it can be taken up tomorrow if you have got the other information.
Lordship.
All right. Kaligira.
Please, your lords. I'm sorry, when Matt was called, I was in another court, my lord. That's why it
Item 50, my lord, on behalf of Mr. Satyavata Panda, with appearing for CGC, my lord, that Director of Revenue Intelligence is not under the central government. His panel lawyer is another person. Tushar Satpathy, his panel lawyers. But his Satyavata Panda name is there, so he's.
No, whosoever it may be, who is to argue there?
Your Lordship, this case should be handed over to DRI, Director of Intelligence Revenue. Today we have been informed that this matter has been listed and we have to appear in this case.
Okay.
If 1 week type may be given and we can take care of the things.
You have got the copy of the appeal memo?
I don't have the copy with us.
Who is to appear? I will.
Tushar Kanti Satpathy, Senior Standing Counsel.
Just Tushar Kanti
Satpathy, Senior Standing Counsel.
Senior Standing Counsel. Union of India.
Central Excise and GST. Central GST and Central Excise Customs.
Central
GST, CGST, Central Excise and Custom.
Central Excise and Custom. Okay. So his name will be reflected in the cause list, and Madam will hand over the copy to you.
3 times supplied the copy.
So the Mr. Panda can be handed over the copy.
Whether it is available with him or not.
It's available.
All right. So ask Mr. Panda to hand over the copy.
Yes,
I'm granting him time. So the submission is made at the bar that Tushar Kanti Satpathy, Senior Standing Counsel, Central GST and Central Excise and Customs, will appear in this case for the respondent, and he will file his appearance memo and stop. Since the learned counsel for the appellant has handed over the copy of the appeal memo to Mr. Satyavrata Panda, Central Government Counsel, the learned Central Government Counsel, who is present in court today, submits that Mr. Panda will hand over the said copy to Mr. Satpathy by tomorrow.
Yes.
Upon tomorrow. Put up this matter in the week commencing from 18th December 2023. Yes. The instruction be obtained in the meantime. Okay.
Yes.
Item number 51.
Can take note tomorrow.
So you have been supplied with the deposition copies?
Yes.
Okay, tomorrow. So 5 December. Okay.
Item number 52.
May it please your lordship. I'm from Kendusha Personal Court.
Yes.
Okay.
Today yes, sir.
Aji ଦେଇଛନ୍ତି Mr. Roy?
No, 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 sir. On 29th 11, my lord. I have served.
ସେ ପଢିନାହାନ୍ତି କାଲି ଏଇଟା ଆସିବ ସେ କହୁଛନ୍ତି ଆଜି ଦେଇଛନ୍ତି ବୋଲି okay tomorrow it will be taken up 5/12/2023 yes next
Item 58.
Let me please, your lordship. The petitioner is convicted under section 452
preposition copy
304205.
wait
Yes, sir.
Page 36.
yeah just what is the conviction and what is the sentence page
36, my lord.
running page or internal
Running page.
36
Yes.
okay that is 304 part 2
Yes.
and 452 so 3 years 5,000 in default to undergo 6 months 452 okay 10 years 5,000 in default to undergo RI for 6 months 304 part 2 all right
Both the sentences shall run concurrent.
all right so it is 10 years
10 years.
and what is the name of the deceased
Which is, my lord, Bobby
yeah
Bisoi. Bobby Bisoi.
B. Bisoi. You are on bail or during trial?
I was on bail during trial, my lord. Was arrested on 12/6/2014 and remained in custody and ultimately
For 5 years.
yes, sir, he has for 5 years. He was released on 27/4/2023.
No, that is date of release is 15/7. Who is in the
15/7.
cause title? It is mentioned there.
I get.
So and after pronouncement of the judgment on 27/4/23, you are taken into custody.
Yes, my lord.
So that means that is 7 months, 5 years and 7 months.
5 years, 7 months.
So is there any eyewitness to the occurrence?
Yes, ma'am.
Eyewitness to the occurrence.
Who is the
PW3 and PW6.
PW3 and PW6 eyewitnesses, and doctor is
PW14.
okay. PW3, as it appears, is a child witness.
Yes, ma'am. 8 years old.
So he is related to the deceased or
Yes,
what?
yes, he is a son.
Son, acha.
Yes.
Occurrence took place also in front of our house. At that time, I was present. And myself, my mother was standing in front of the accused persons, namely Swanso, came and quarreled. Then they told my mother to ଆମ ନାମରେ ପୋଲିସକୁ ମିଛ report କରିଛୁ. Thereafter, the accused Sunita caught hold of the hair of my mother, and both of them assaulted my mother. And out of fear, my mother entered into our house. Both the accused also entered into our house, dragged my mother to outside by holding her hair. At that time, accused Surjo Nayak reached there and told accused Chatura to kill my mother. So the accused Chatura means this present appellant, okay, went to his house, brought a sword, dealt two blows on the head of my mother. And thereafter, the okay. Thereafter, accused Surjo snatched away the sword from accused Chatura and also dealt blows on the neck and hand of the. So my mother fell on the ground and died at the spot. At that time of assault, accused Sunita Naik was dragging my mother by holding his hand. Thereafter, all the accused person threatened to kill. Okay. So He has narrated the incident in detail. Anything has been brought out in the cross-examination? So who is, let us see first the doctor's evidence. PW 14.
Yes.
Okay. So inside wound on the middle part of the left arm. Okay. Then next one is also right arm. Chopped wound. Okay. On the right nostril nose. Then chopped wound right ear. Injury number 5 just below throat. So 5 blows were given, 5 or 6, 6 blows. And 6 were chopped wounds, number of chopped wounds. Neck.
There are 3 accused persons were there. The present petitioner has inflicted.
You are the person who assaulted on the vital part of the body, that is the head. And on the head also there are injuries. You come that number 4 you see, chopped wound of so-and-so in the middle of the pinna of the right ear to the right posterior temporal aspect of the skull. This is one. आरटा मध्य से जो right neck रे उठा अच्छी then so why he was found guilty under section 304 part 2, why not 302? What is the reason?
Absence of motive,
Came with a sword, assaulted on the vital part of the body like head, there are chopped wound, and you say no motive. Motive kono?
Yeah, all of that heat of the moment, my lord, the occurrence took place. Yes, no.
You are the aggressor. You came to the deceased house ଏବଂ ତାଙ୍କୁ କହିଲେ ତୁ ଆମ ନାଁରେ ପୋଲିସରେ ମିଛ କେସ୍ କରୁଛୁ। ତାପରେ ଜଣେ ସେ ଲେଡି କିଏ ଗୋଟେ ସିଏ ଡିସିଜ୍ଡର ବାଳକୁ ଧରିଲା and assault କଲା, then ଗୋଟେ ଇନଷ୍ଟିଗେସନ କଲା ଆପଣଙ୍କୁ, ଆପଣ ଯାଇ ଘରୁ ଖଣ୍ଡା ଆଣିଲେ, ତା ଦେହରେ ରିପିଟେଡ ବ୍ଲୋଜ ଦେଲେ and ଆଉ ଗୋଟେ ଆକ୍ୟୁଜ ସ୍ନାଚ ଆୱେ କଲା ଆପଣଙ୍କ ହାତରୁ, ସିଏ ବି ମାରଲା ନେକ୍ ଆଉ ହ୍ୟାଣ୍ଡରେ, and that resulted in the death of the deceased. 5 years, 7 months.
You shall also kindly consider the petitioner has improved himself. He has being a murder convict, being under in the jail, my lord, he has produced LED bulbs, and he has also that has also been
LED
conduct has improved, my lord. And the news articles have come that border convict produces LED bulbs, emergency light after jail training. Has improved, his conduct has improved.
ସେ ରହୁନାହାନ୍ତି, ସେ ତ ଭଲ
ସେ ବାହାରୁ
ଜେଲ ଅନ୍ଧାର ହବନି, ଜେଲ ତ ଲାଇଟ୍।
no previous antecedent. It has happened out of as a hit at the
कौन
heat of the
देखी
moment.
कौन से जेल लाइट कौन बोल
conduct improve करछि 5.5 वर्ष कहलानी।
State Council will oppose the bail application on the ground that ଆପଣ ଚାଲିଗଲେ ତାଙ୍କ ଜେଲ ଅନ୍ଧାର ହେଇଯିବ। Or the Learned Council for the appellant, Learned Council for the state, considering the submission made by the Learned Council for the appellant that out of 10 years of substantive sentence imposed on the appellant, he has already undergone 5 years and 7 months, both during trial as well as after conviction, and that he was granted bail by the during trial after remaining in custody for 5 years. And after going through the evidence of the two eyewitnesses, that is PW3 and PW6, so also the doctor PW14 placed by the Land Council for the state. And since it's a criminal appeal of the year 2023 and there is no chance of early hearing of the appeal, and there is no criminal antecedent against the petitioner, I am inclined to release the petitioner on bail, stay realization of fine.
Item 59.
May I please? 10 years conviction.
Just
Item 64.
Your Lordship, my lord, in this matter, the appellant has been convicted for 10 years and CRLA 709 by 23. He has been convicted of 10 years. My lord,
You want to argue the matter or adjournment, seeking for adjournment?
argue.
Argue the matter. You have received the deposition copies, right? Which item you want to? There are two matters.
CRLA 709 of 23.
The last order, my lord, directed to produce some judgment. Which on which in this case, your lordship, that is 30/10/2023, your lordship passed order. 30/10/2023. Is the application on 389, my lord. She is asking for bail. Lordship
My lord,
write some judgment.
my lord, in this matter, Section 42 of NDPS Act has not been complied, and it has been
That has already that must have been dealt with by the learned trial court. So, if I give a finding at the stage of consideration of the bail application, then what will remain at the stage of final hearing of the appeal? Whether the learned trial court has not considered 42. In paragraph 13, he has stated about that. That the PR report shows recovery of so and so. Prosecution has to prove necessary compliance of section 42(1) of the NDPS Act. As for the so and so, then he has quoted the section and what is required to be done under section 42. Then he says whether the evidence proved that, then he says paragraph 15 regarding subsequent compliance of 42. Both PW2 and PW3 claimed in their evidence that PW3 gave the said written information to his immediate superior officer, IIC, EI and EB, Unit 1 Cuttack, and took his signature, so and so. To prove the claim of supply of so and so, prosecution has also proved his signature. Okay. Defense did not dispute the signature of the IIC, which is available below the signature of the IIC's preparation of the same. Beside the body of the document, Martin in mentioned that the IU got the information about the transportation of ganja, hence note down the same. In such a situation, basing on one overwriting of so and so, it cannot be said that the document was tampered, and this court did not believe the submission of the defense that Exhibit 14 is a document prepared subsequently for the purpose of this case. Therefore, taking into account the oral and documentary evidence of the prosecution, this court is of the opinion that the prosecution well proved that on the above date, so and so IU come seizing officer got the information about the transportation of ganja and note down the same into writing. Then subsequent compliance, in that case also it has been discussed that the IO says that in his evidence admitted Deputy Superintendent of Excise is the immediate superior authority and serving the copy of the information to IAS is not deemed to have been service of copy of the notice to this one. So therefore further question arises whether IAC so and so was then the immediate superior authority of the inspectors one. So it is not in dispute that were the same rank, the officers. So again, it is also not disputed that the inspector S party was the then IAC so and so was attached to the office of the inspector. During the cross-examination, PW3 in his evidence admitted in a sequence that SI of sponsor is superior to assistant and inspector is superior to SI of excise, and in the above process, deputy superintendent of excise is superior to inspector of excise. Therefore, the question arises whether such part of the evidence of PW3 can be considered as admission of PW3 regarding his higher authority. But in this regard, this court carefully examined the evidence of so and so this witness. He gave the information to his immediate superior, IAC exercise. Therefore, in such a situation, the answer to PW3 to the subsequent one put to him during cross-examination regarding his superior authority is not found as clear-cut admission of PW3 regarding immediate superior. So the trial court's finding is that 42 has been complied with. He has discussed it. Whether his finding would be correct or not, whether it would be legally sustainable or not, that is to be adjudicated at the time of trial. Final hearing of the appeal. It cannot be decided here.
Lord,
Yes, make your submission.
my lord, in some of the orders, as I am appearing for bail in this matter, my lord, as I am appearing for the bail in this matter, and here in the cross-examination, the IIC, who is the IO, has stated that DSP is the superior of authority of inspector in this matter, and accordingly, Section 42 has not been complied, and in the light of that, some orders are there of our High Court.
It depends upon the individual cases. It's depend on the factual scenario of the case, how the evidence has been, and it is the assessment of the learned trial court. So that is to be set at not at the appropriate stage, not at the bail stage. Detailed documentation on the merits of the case is to be avoided. That is the settled principle. If at this stage I decide all those things, then nothing will be left. Even if at the final stage the court may come to a different opinion. He may agree. The court may agree with the finding of the learned trial court. So therefore, it is not proper to give any such finding at this stage, which is likely to be prejudicial to either of the party. If I say no, if I discuss your contention and say no, rightly held, then that will go against you because you may not get the scope to argue again, because there is always a finding against you. And similarly, if I say yes, 42 not complied with, it may go against the state. So this is not the stage here to adjudicate all those things. So it's a case of commercial quantity of ganja, na?
Yes, ma'am.
125 kg. You are in custody for how many years?
2 years, 8 months.
Or at least this matter in February 2024. Along with CRLN number 700 of 2023. Rest of the matter tomorrow.